Alex here with part 205 of the My Docket series on child custody and visitation. As with our previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimer and the underlying purpose of the series. Two things that I glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. You guys can see Brittany's back. This is because we are at another adoption. I always love to see you. I'm sure they love to see you too. Another adoption video. This is probably the second to last one. We have one more where we actually go through the video. I don't think we have anything else. We have mindset for the orders. So what was your mindset on getting the order coming back from the judge granting our request to waive CPS and DFS coming over and snooping around our house?
What was the question? What was my what?
How did you feel about that?
About them coming over to the house?
No, about the judge's order waiving that requirement.
Oh, it seemed logical.
Yeah, it did. So I think the only other thing is an order setting hearing. How did you feel to get because that's also coming up in this video. How did you feel to get the order setting the hearing for the adoption?
I couldn't wait. I was nervous. It was a long time coming.
Yeah.
But it was finally almost here,
Yeah. How did you feel about the possibility that she might show up and contest the termination of parental rights?
How did I feel about the possibility? I thought it was really unlikely.
Me too.
Like 0% chance. So I didn't really, I think that the most nerve-wracking thing was her family showing up, which I think her brother did, right?
Yeah, he did.
Yeah.
All that being said, let's take a look at what I have filed. Here we have the order waiving welfare investigation. I wanted to mention that I looked at the next few documents. I can't see anything that jumps out at me as something that Brittany would want to comment on. It's just a bunch of procedural stuff for the most part. In fact, it's not just for the most part, it's just purely procedural stuff. So I think that Brittany's going to head over and start making some food for us for dinner, and you can go ahead and say bye.
Bye.
See ya. All right, I'm going to go ahead and continue now. Okay, so we have the order for waiver of welfare investigation. It looks like I got the title a little off there. In any event, the standard introductory paragraph indicates this is a step-parent adoption brought by married petitioners who seek approval of the court for an adoption of a minor child. And going into the next paragraph, we have so petitioner, the natural father, has been awarded primary physical and sole legal custody by the Second Judicial District Court. My wife is a stepmother of the child and has known him for 3 years. This is the proposed order, guys, but since it's signed now, I'm going to go through it. The child has primarily resided with petitioners as of November 4th, 2014. I have instituted termination of parental rights proceedings against my ex. The law, if one petitioner of the spouse of a petitioner is related to the child within the third degree of consanguinity, the court may, in its discretion, waive the investigation by the agency which provides child welfare services. I, the natural father, am within the third degree of consanguinity. The court notes that the Second Judicial District Court characterized my wife as follows, and then we already went over this verbatim. The court finds good cause to waive the investigation. Petitioners are obligated to quote send quote a copy of the order waiving the investigation to the nearest office of the agency which provides child welfare services by the petitioners within 7 days after the order is issued, unquote. And by the way, just in case you guys couldn't tell, this is a requirement imposed by statute. So the same statute that allows us to get a waiver of the welfare investigation also allows us to get also requires us to send that order waiving to CPS/DFS. The court also finds good cause to waive the requirement that we file an affidavit setting forth fees, donations, and expenses. This is an interesting law. I'm not sure what the requirement is for. Maybe it's because the court is concerned that the people who are adopting the child are being funded by somebody else, or maybe it has to do with their inability to take care of the child financially. I'm not sure why this is a requirement, but in any event, it doesn't matter because we got a waiver to that requirement as well, and the basis for that waiver is the same. The court hereby orders that the investigation and report generally required by the agency which provides child welfare services in adoption proceedings is hereby waived. The court further orders that the requirement of filing the affidavit setting forth fees, donations, and expenses is also waived, and the court orders that we send this order to the Nevada Division of Child and Family Services. That's it. Next document. Notice of compliance. So here we are filing a notice of complying with the court's order for waiver of welfare investigation, specifically the portion of the order that required us to mail this to the Department of Family Services. Next, we have the notice of readiness and request for setting. Now, this is definitely required. I noticed that with the petition for termination of parental rights, the clerk issues the notice of hearing immediately upon the filing of the petition. However, for the adoption, the same thing does not occur. So I got curious, so I did some research. I looked into the EDCR and I found 2.20 sub K and 5.11 sub D. I'm not sure which one of those two it is, but one of those two specifically says that when everything in an adoption proceeding has been taken care of, and what I assume is the consents have been filed, service and maybe, well, in this particular case, the waivers have been taken care of. I would assume that in some cases that waivers do not apply. The actual report is filed by the child welfare agency. And so I found one of those two rules, whichever one it is. One of those two rules specifically says once you're ready, you go ahead and file a notice of readiness and request for setting. And that's what we're doing here. We are complying with those local rules. And I would imagine it would be different in another district. So, for example, in District 2, you'd probably just file a notice to set. But this is District 8, so that, things work a little differently. Anyway, in compliance with that rule, I filed this notice, and this did trigger a hearing, as you will find out now. So here we have the order setting hearing filed by the District Court Judge. The District Court Judge is ordering as follows. First, we have a standard introductory paragraph indicating this is a step-parent adoption brought by married petitioners who seek approval of the court on the adoption of a minor child. The welfare investigation and report has been waived. The requirement to file an affidavit setting forth fees has been waived. The next paragraph here asserts that the consent of the child's living natural mother has not been filed with the court as required by statute. However, the termination of her parental rights would obviate the requirement of her consent, and that is stated in another statute. So NRS 127.043 sub 1 says that you cannot adopt a child unless you have consent of the natural parents and or the legal custodian of the child. However, there is another statute, that's statute 127.090, which states that if you terminate the parent's parental rights, you no longer require their consent. This is the only way to adopt a child over the objection of a natural parent. A hearing has been scheduled for the termination of the child's parental rights August 9th, 2016 at 8:30 a.m. It would be an efficient use of judicial resources to set the hearing on this adoption on the same date and time so that this court can resolve both matters simultaneously. Again, guys, I mentioned this, I think 3 videos back, that I don't recommend doing this, and I stand by that. It didn't backfire on me. It worked out perfectly. However, it could have backfired, and it would not have been a good situation for our child had she appeared at the courthouse. So I don't recommend setting these things simultaneously. I recommend you resolve the TPR first, and then you file to have the adoption hearing pop up second. The consent of a minor child of age 9 is not necessary, and that is because of a statute. NRS 127.020 sub 1b states that the consent of the child is necessary in certain circumstances, and the child, I believe, has to be at least 14, if I remember correctly. Please don't quote me on that. Please look it up for yourself. Even if I was right, that could change. Laws change sometimes. So always check into these statutes yourself, especially if you're not even in the state, because then it's completely different. Anyway, the adoption proceedings are non-adversarial and should nevertheless include the child. And that's a local rule 5.06 that says you have to get permission from the court to bring the child to court. It is hereby ordered that parties shall appear for hearing on this adoption matter on August 9th, 2016 at 8:30 a.m. And it is hereby ordered that parties shall arrange for the production of the child at the hearing, which is pretty standard for adoption cases. And like I mentioned, potentially required depending on the applicability of 127.020 sub 1b. Going into, that's it. Going into the aftermath, we filed 2 documents, but they were free filings, so we incurred $0 in costs. We didn't have an attorney, so we incurred $0 in attorney fees. As on the previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.